And by then it's going to be way too late, right? We'll have either violated it or not violated it, and you'll never know in time. So again, chatting and email or instant messaging, you know it's contemporaneous by its nature. Emails, you don't know. I think it's fine to disseminate information, but don't get into an interactive communication. And again, that looks much more like your phone conversation, right? You don't just call someone and talk with no reply. They're by nature kind of interactive. So that's my discussion and advice with respect to that fairly recent change with respect to contemporaneous interactive communications. Yes, sir.
Another hypothetical.
Okay.
I know that on a particular night there's going to be a vote, and the vote is 4-4, and there's one person who hasn't yet decided. Mm-hmm. That's only one person. What are the ethical and legal implications of my, say, calling that person in order to persuade him or her to my preferred position?
The time of the 4-4 vote, that person's not here, is not participating.
But it's coming tonight, so I want to convince.
Oh, in advance.
I want to convince that person to vote my side.
Well, again, if we're talking a board, 9, majority of a quorum being 3, a 2-person conversation, one-on-one, is acceptable. It's not a violation. It's not a meeting because it doesn't fit the meeting definition.
Even though it's private, outside of the open meeting.
Well, you have no baggage of the Open Meetings Act, no notice, no agenda, no minutes. That's true, but you have no meeting.
No, there's going to be a meeting.
No.
Oh, you mean when
the phone conversation you're describing is not a meeting.
Okay.
Now, I will say to be cautionary, because the phone and for that matter, individual emails could lead to this also. What you want to avoid is not what you described, the one-on-one conversation and debate or persuasion. That's perfectly proper, perfectly fine. But what I described earlier briefly as sequential phone conversations. In other words, if you call that person and you said, we really want to give Dee a raise, and it's a 4-4 vote, and you're going to be the swing vote, and if you can get to 5-4, then it'll happen. That by itself wouldn't be a problem, wouldn't be illegal. But don't call another board member and have a conversation and say, you need to call so-and-so to tell him that. Because now it may be 5 minutes apart or even 5 hours apart, but you're obfuscating. In other words, you've occluded 3. Now we have a majority of a quorum in a big net anyway, and the purpose of the call is discussion of public business, and it, frankly, for libraries, we're in my experience is we're both cautious and attentive to these kinds of considerations, and we know that when we're engaged in conversations face-to-face on church house steps or phone conversations sequential, we know if we're trying to avoid a vote. I mean, a meeting, discussion, and vote. And by the way, the other thing that strikes me, I'm a long way from 4 years old anymore, but those of you that have children that are 4 know the game of telephone. And you know if you whisper in one kid's ear and they whisper in the next kid's ear and the next kid's ear, by the time it comes out is totally different than the first kid. That's just my metaphor or visualization of it's a very poor way to conduct public business. Probably any business, but certainly public business. That you don't have that discourse at some level anyway, that discourse in an open meeting. Well, not necessarily open, it could be closed. I mean, that's another topic. But at least a meeting where electronically or in person, everybody sort of gets to participate and hear that persuasion on the one side or opposing view on the other side. So one-on-one conversation is perfectly legal and proper, but don't make it part of a sequential, especially when it appears to be an avoidance of the meeting, would be my preachment. So that, I guess, sort of brings us, in a sense, I alluded to the reasons for closing session, but let me back up, say this. because it's often misunderstood too. The law says any properly convened meeting. So, got notice, got agenda. It might be 48-hour special meeting, might be one of those for the whole year. But any properly convened meeting can be recessed into a closed session if you follow those checklists, but basically a motion to go into closed session is voted on and a majority prevails. A reason permitted by the statute is to be discussed. I'll go on, I haven't mentioned yet, you need a recorder, because a verbatim recording is required, and you'll need a minute taker because you have to have minutes. But my real point here in saying this, any properly convened meeting can be recessed into closed session upon the proper procedures I talked about. I get this question once a week, at least. It comes a couple of different ways. One is, I was in a meeting last night and they went into closed session and it didn't say anything on the agenda about going into closed session. Or, we're having a meeting tonight, got the agenda, it's been up for 2 days, and we need to go into closed session to talk about this one thing that's on there, buying property or giving raises, and it didn't say we're going to have a closed session on the agenda. Can we discuss it in closed session? Yes, the answer to all of that is yes. Again, any properly convened meeting, notice, agenda, can be recessed to closed session if you follow those procedures. You have the bona fide reason on the exemption list or exception list. You have the vote to go into closed session specifying the reason, and it passes. So what I call listing on the agenda, executive session or closed session, again, a lot of cities and schools it's on every agenda, is simply a courtesy. That's the only way I can describe it. It is not legally required. It is a courtesy. And by the way, under Rice versus Adams County, which dealt with the category agenda entry old business, and some people even say new business because that's very similar, I'll throw in closed session. The statement or inclusion of that verbiage on your agenda serves you not one whit. It legally. They're unnecessary and they don't accomplish anything legally. Now, they might be fine. I mean, it's fine to be courteous and it's fine to group things on your agenda that you talked about before under old business and group things under new business, and for that matter, alert people that it's closed session. That's a courtesy and that's fine. But if you don't have something on the agenda that, I'm going to say itemizes, that's not the word the law uses, but that lists the topic, then two things happen. If it's a special meeting, you're not even really supposed to discuss it. You certainly can't vote on it. Regular meeting, which was really the Rice case, if you have old business, and that's all it says, or you had closed meeting, that's all it says, you can't go debate, you can discuss, but you can't go vote to take action on a topic that's not listed on the agenda. Okay? That's the dictum or the holding of Rice versus Adams County and a few cases. By the way, Rice versus Adams County, maybe I should talk a little bit about that. That's a case several years ago now where Quincy is Adams County, where the county board there had discussed a couple of times, months before, a golden parachute for its top couple of employees who were going to be, I don't know if it was retired or fired, but they were going to get a lot of extra benefits on retirement, costing a lot of IMRF tax money. That's the background. The case doesn't talk about that, but that's what it was about. And I think it was in December, certainly November, December, late in the year, right before the deadline, not on the agenda, nothing on the agenda of this county board meeting at all. Somebody says, I want to discuss the golden parachute, early retirement or whatever it was, plan. And it wasn't on the agenda. It had been, months before. They actually put it under new business, even though it was really old business because it had been discussed before. That didn't matter. And they voted in. It cost the taxpayers, I don't know, several $100,000 if it had gone through. Peoria County, about the same time, was voting it down. I don't know about DeKalb County. A lot of counties faced that same choice, thought it was too burdensome on their taxpayers for that, incentive, and they either didn't vote on it at all or certainly didn't approve it. Well, Adams County approved it. And of course, some taxpayer objector, Mr. Adams, sued and said, well, it wasn't on the agenda. The statute reads today like it read then, and it says an agenda specifying the topics is required for special meetings. And I can't put my finger on the section, but for regular meetings, your regular monthly meetings, like the county's regular monthly meetings, basically said failure to list something on the agenda did not prohibit consideration of the item. That's almost an exact quote, but it's a paraphrase. So the Adams County State's Attorney said, well, we considered the golden parachute. It wasn't on the agenda, but the statute says failure to list it on the agenda didn't prohibit consideration at a regular meeting. And the appellate court, in fine lawyer fashion, parsed the word consideration. And it says, ultimately, consideration means discussion and debate. It doesn't mean voting. So that's where they drew the line. You can discuss something not on the agenda, but you can't vote unless it had said something like pension or IMRF or golden parachute or something to hang your hat on. Many lawyers that chat about these things have said, well, it's bad facts or hard facts make bad law, and that's sort of what happens with Quint. The taxpayers are so against it, it was so extravagant expense, the court was almost looking for a way to throw it out, and they did throw it out. Now, we've had a couple of cases since where the courts have been a little bit more forgiving, and so they haven't required, and you may see this, and I see it in a lot of cities and school districts, their agenda runs 30 pages. They have almost every word of the motions that are permitted or not. I don't advise that. I think that's crazy. That's handcuffing yourself, and it's not required by any cases and not required by the statute. And if you use agendas like that, I think it's very misguided in the other direction. The things will come up, especially when you only meet once a month, where you want to attend to it, discuss, but maybe even vote on it. So that's the Adams County and agenda sort of requirements. But now, let me back. I'm not sure how I got there from closed sessions, but we do have, a few years ago, the amendment that requires a verbatim recording of any closed session. My first lesson is, if you don't have a recorder, you're never going to be able to meet in closed session and comply, right? So whether it's a video recorder, a digital recorder, I don't care the mechanism. I've seen some governments spend way too much money for systems that don't work too well. And when this was passed against the proponents were the News Media Association, sort of my enemy and fans and friends all together in one group, they made a point in their testimony that a $39 Radio Shack recorder was all that was required. It wasn't going to be a huge unfunded mandate. So we still stand by that. You don't have to spend a lot of money on a recorder for the verbatim recording required in a closed session. I will say this, anybody who's been around recordings, including probably this one, no offense, will know you don't need Richard Nixon and Rosemary Woods to say there's going to be lots of gaps, lots of silence, I can't figure out who's talking. The questions, from others, they may not have heard you, and I apologize. So, things happen at these meetings where they're taped that don't really serve much of a public purpose, but that's what our statute does require, and we certainly do a good faith effort in complying with that requirement, as idiotic as I really think it may be. But I've got to talk about a couple of other aspects of the verbatim recording. First, I'll take the simple one under the statute that says the tapes. And these aren't tapes like of an open meeting or for the use of a secretary taking minutes. These are legally required tapes. You must preserve them. I say secretly, or meaning, confidentially. We'll get into that aspect a little bit later on. But you must preserve them until three things happen. 1, 18 months passes. So these aren't the kind of tapes, I don't know about if you even use open session tapes. A lot of people use them just for note-taking purposes, and they record, they erase over them the next meeting. You can't do that with verbatim recordings of closed sessions because you have to have at least 18 months minimum, first thing. Second thing is, and by the way, destruction of the tapes at the end of 18 months in these three events is an exception to the Local Records Act. There aren't many exceptions to the Local Records Act. Generally, you can't destroy local records, public records, without the written permission of the state, of the archivist, the local records archivist. But when they did this statute, they at least said you can destroy these. If you do these three things, you can destroy these without permission of the local archivist, just for those of you who care about that. 18 months must pass. Written minutes in compliance with the Act must exist. They don't say you must use Phil's form, although I'm pushing for that someday, but you have to have the written minutes in compliance with the Act existing. Of course, most people do minutes fairly promptly. They don't wait 18 months. The third thing is a vote of the board must happen to destroy the particular meeting tapes. Now, you don't have to have one motion for one tape. I mean, you can take a motion. By the way, you can't take a motion to destroy all past tapes over 18 months. That doesn't suffice because that doesn't particularize the tapes you want destroyed. So you'd have to say, you might say they're not going to be 20 for a library, but there may be 3, say, that are all, from 3 years ago, and you move to destroy April 18th, 1998's tape, or you wouldn't have taped back then, but you can have the actual dates and there can be a gathering of them, but you need a motion of action of the board to destroy. So those are the 3 things that have to happen to destroy the tape. I'm foreshadowing a topic we're going to talk about biannual review of minutes of closed sessions. You do not have to biannually review the tapes of the closed sessions, because that's accepted. But the other thing I want to talk about when it comes to verbatim taping, and maybe it's a symbol of how bad the Open Meetings Act is in the game of gotcha, because there's a lot of gotcha involved with this if you haven't picked that up by now. When the original verbatim taping statute amendment was passed, it included a section, and it's sort of still in here, that says the tapes can be used for one purpose only. The tapes of the closed session, until released, if you ever release them, there's no real reason to do that, but if you did release them, that'd be public, that'd be a different thing. But tapes of a closed session could only be used for one purpose. That was to be listened to by a judge in the circuit court upon a complaint filing of a violation of the Open Meetings Act. And that's a pretty close paraphrase. That was the only purpose the verbatim tape could be used for when it was originally written. And I point that out, A, because it's been changed, and B, because that ought to tell you something about why the statute was amended by the Press Association to require taping. You don't have to be Blagojevich to know the taping. These tapes were for one purpose only, to develop evidence against local governments. It's one of the reasons I don't like the statute. I don't think that's a good reason to spend money of the taxpayers to develop evidence, because that's the only purpose it could be used for under the express statute. So that ought to tell you something. Well, it was about a year before the first change, and the change did not occur by statute. The first change occurred in the federal court in Chicago. It was a fireman case. I'm sorry?
No.
Oh, fireman's case. I thought you were telling me I had 5 minutes left. I was going to say, oh, God, better start talking. A fireman case where the fireman had been fired by a board, a police and fire commissioner or some kind of board, fire district board, whatever it was, and hired a lawyer and sued for discrimination and wrongful termination. And as you might imagine, his attorney, doing his job, subpoenaed the tape of the verbatim session that preceded his termination. And the defense, the in front of the federal court was, sir, the very statute that required the taping last year says right here, state law, that there's only one purpose the tape could be used, and that's where there's by the judge to listen to it in camera, in chambers they call that, when a violation of the Open Meetings Act is claimed. This fireman doesn't claim we violated the Open Meetings Act. In fact, they know we followed the Open Meetings Act, and we taped it. The federal judge took about 2 minutes to say, I don't care what Illinois law says. We're the U.S. government, and we fought a civil war over this. Our law, the U.S. government law, triumphs over state law. And I'm here to tell you, give them the tape. Because in discovery, lawyers call this, alleging a civil rights violation, this attorney and plaintiff have a right to all evidence, including this tape. Well, they didn't turn the tape over because the case settled within about a day. I don't know what was on the tape. I can guess that they said some things on that tape that offended this gentleman or discriminated against this. Nobody knows. I just know, and there's been one case since, about a year ago, second time, federal court says tapes of closed sessions must be produced when civil rights allegations occur. So now we have two reasons, right? And the third, which is fairly recent, went into effect January 1st, 2010, is our friend, her name is Smith, Kara Smith. She's the public access counselor at the Illinois Attorney General's office, the PAC, as it's called. When that statute went into effect, it's mostly known as the Freedom of Information Act amendment, but there's a couple of sections that it did other things. One is it created the PAC office and set of lawyers that they've hired since. And two, it amended the Open Meetings Act, a couple of small places that I'll talk about. But one of the amendments was the PAC can listen to the tape when there's any challenge to the violation. So it's not just a judge now, it's the PAC. I will say challenges to the Open Meetings Act have to be made within 60 days. There's a short time frame, so it's not any challenge. It's just a prompt challenge. So that's more history maybe about verbatim recordings than you want to know, but that's kind of the coverage. I'm not going to spend much time, but I do have on my list of topics here. Illinois, under the Open Meetings Act, basically applies to public bodies. Advisory groups, groups appointed by the library, but not so expansive as some states that apply to all not-for-profits, charities, broader application. We don't really care about that because we're talking about the library anyway. And it doesn't apply to your friends group, although there's people that want it to apply to the friends group, and it can be voluntarily followed, but it's not required to be followed by those kinds of groups. Okay, I've alluded to a couple times, but let me come at meetings from a different perspective entirely now and say there are 4 types of meetings under this statute. The first are the regular meetings. Those are what you think of as your monthly meeting, usually established at the start of the fiscal year or the start of the calendar year. What I call the third Thursday or the second Tuesday or whatever it might be. And I've already talked about regular meetings and the agenda requirement and the consideration of aspects, but I will say this about it. There's only one time under the Open Meetings Act that you have to, what I call, buy an ad, meaning put a notice in your newspaper of a meeting under the Open Meetings Act. You can waste money all you want buying ads in newspapers, but it's never required except one time. And that is if the start of your fiscal year, you pick the third Thursday of every month for your regular meetings, and sometime during the year, maybe the next month, maybe 8 months later, that turns out to be a very bad night for several of your members, and they plead with you to move it to the second Monday. All the rest of the meetings, not one meeting moved, but all the rest, however many that is, 11 or 3. If you change the regular meeting date mid-year, then you're required to publish that in the newspaper, that change to new dates. Not a single meeting, all the rest of it. So that's the only time it speaks about published notice. Posting is what I was talking about otherwise. Second kind of meeting, special meetings. Special meetings are meetings by definition called upon a minimum of 48 hours posted notice. And your discussion, but more importantly, your voting is limited to what's listed on the agenda, of course. Third type, I mentioned earlier, the reconvened meetings. We'll use tonight as a good example. If you're in a meeting, properly noticed, convened, and you're here, and you get tired or whatever the reason, you've exhausted the clock or heaven knows the reasons, and you say, we've got to go home and get some sleep, or we got to stop this. But can you come back tomorrow morning at 10 o'clock? You can reconvene this meeting it has two requirements. Three requirements. One, it must be reconvened within 24 hours. That's why I picked 10 o'clock tomorrow, or 7:30 tomorrow. It's got to be within 24 hours. Two, it's publicly announced at this meeting when we're reconvening. That's the notice of the reconvening. And the three is the big one. You can't alter the agenda you started with. That's also the reason we don't have many of these. A few times I get involved when we go real late, we'll reconvene the next day. But it's not a solution to a defective agenda problem, if you're following me. You had whatever agenda brought us together, that's all you could vote on tonight. So reconvening at 10 tomorrow doesn't give you a power to vote on something else. For that, you're going to need either a special meeting, 48 hours notice, or my final type, the fourth type, are emergency meetings. Now, let me say a few words about emergency meetings. Again, notice could be instantaneous. I mean, if it's a true emergency, you're not going to have a lot of notice. In fact, please, call me with a common question I get to say, Phil, we need an emergency meeting. It's 95 degrees out and our air conditioning failed, and we got to get it fixed because people can't be at the library under these terrible conditions. We need an emergency, and we want to meet. My board will all be together, and my HVAC repair guy is going to have his numbers together and his brochures together. Can we meet at 10 o'clock Friday morning? Why do I say that? It's more than 48 hours from now. By definition, it's not an emergency. That's a special meeting. Post a notice by 10 a.m. Wednesday for Friday. That's that meeting. Now, it's not that we don't have emergencies. Once in a blue moon, tornado or such, you might see an emergency, meaning we have to meet now or within an hour or within 3 hours. So yes, there are true emergencies, and the Act accommodates those kinds of emergencies. But an emergency, and by the way, it'd be perfectly fine and businesslike and appropriate, it seems to me, if your air conditioning went out, you might even have to close a day, to get solutions, to get inspections, to get prices, to get all of you, or as many of you as possible, spur of the moment, so to speak, in Friday. There's nothing wrong with any of that. It's just that it's by definition not an emergency because it's more than 48 hours. That's my only point.
Question.
Yes.
If you, hypothetically, let's say that we have a boiler failure, and we have water running through the library, which is a bad thing.
Yes, it is.
Dean calls up Wendell and says, we have to meet, because we're going to spend money to have this repaired.
Right.
That's an emergency. I assume that meets that criteria.
Yeah, so far.
So then, what is specified is the requirements of the board for making minutes and taping of that emergency meeting?
Well, by and large, I'm going to guess that there's nothing that needs to go into closed session. Now, that's my guess, because there could be components that are proper to discuss in closed session, and any properly convened meeting, if you're here at that emergency, an hour later even, and you've got a quorum, you may have some components, and I'll give you an example or two in just a second, that you go to closed session for that portion of it. Your quote agenda, because an agenda is preferred just to conduct the meeting, but it may be handwritten and may not be much. The emergency topics related to the water leak and the fix and the salvage and the cleanup or whatever. It has to be related.